Security, escort this gentleman out, please.
Come on, Soda Pop, let's go.
All right, so now let's get back into the issues. We're going to start with Referred Law 19, which would revise certain provisions regarding elections and election petitions. Now, while we have documented outreach to the proponents of Referred Law 19, inviting someone to attend tonight, no one has been able to attend. So to share a little more information on this Referred Law prior to hearing from the opposition, I'm going to share the Attorney General's explanation of Referred Law 19. The title, to enact to revise state laws regarding elections and election petitions. The Attorney General's explanation. Currently, primary election candidates for certain offices must circulate and submit nominating petitions between January 1st and the last Tuesday in March. Referred Law 19 changes that time frame to between December 1st and the first Tuesday in March. The Referred Law also changes other election-related submission deadlines, adjusting them from the last Tuesday in March to the first Tuesday in March. Certain election-related documents, including nominating petitions, are currently considered timely submitted if sent by registered mail before the deadline. The Referred Law changes this to require that these documents be received by the submission deadline. It also changes the method for calculating the number of signatures required in nominating petitions for certain elected offices. The Referred Law prohibits a person registered with a recognized political party from signing an independent candidate's nominating petition. The current law does not contain that prohibition. Under the Referred Law, an independent governor candidate cannot appear on the ballot if the corresponding lieutenant governor candidate withdraws and a replacement is not certified by the second Tuesday in August. It also restricts the circumstances under which a political party may replace a candidate who has withdrawn from consideration after the primary election. A vote yes is for revising state laws regarding elections and election petitions, and a vote no is against the Referred Law. So with that additional information, I'm now going to turn to Mr. Cory Heidelberger, who is representing the opposition to this Referred Law, and you have 3 minutes to give an opening statement.
Thank you, Sarah. Thank you, League of Women Voters in the Chamber, for this opportunity to educate the voters. I think this is extremely valuable. That's why I was willing to come down from Aberdeen today to talk about Referred Law 19. We'll talk about 20 as well. I'm somewhat disappointed and surprised that nobody would come to speak in favor of Referred Law 19. Here in Sioux Falls touches, I think, 9 different legislative districts, and there are numerous legislators from this county area who supported Referred Law 19 in the legislature. They voted for Senate Bill 69. They thought it was a great idea. The governor signed it. There are numerous proponents, supposedly, who felt this was good enough to write into law, but apparently they're changing their minds or just hoping we'll all forget about it because they didn't want to come to this forum tonight. So be it. Enough sour grapes about the chicken opposition. Let's talk about why this is a bad bill. Referred Law 19 does 3 major things. It does a lot of changes to election law, and I apologize. This is election nerd stuff. This is the kind of thing that us guys with spreadsheets and petitions love to talk about. But as election nerd stuff, this law does 3 big things that make elections worse, that make them less fair, and that ultimately lead to you voters, to all of us, having fewer choices on the ballot come November. The first major change that Referred Law 19 makes is it moves the deadline for candidates to submit their petitions from the end of March to the beginning of March. Now, in return for losing that time, candidates get to start circulating their petitions on December 1st, the year before the election. The practical impact of that deadline change is this. Candidates lose the warmer, brighter, longer days of March when they can actually go door to door, stand on the sidewalk, and not have to pull their pen out of their parka and hand their petitions to freezing people, at least on some days in March. It is more likely. It's nicer in March for doing petitions. In return, Referred Law 19 allows candidates to start circulating in December, the coldest, darkest, gloomiest, and arguably busiest days of the year, since everybody's busy running out Christmas shopping and going to Christmas parties and all that. If you think signing a petition in January, February, or March is a hassle, try asking someone to sign a petition when they're trying to get that last new special edition Barbie for Junior or Juniorette, whoever it is. Referred Law 19 means people will have to decide sooner to circulate, they'll have less good days to circulate, and that just means ultimately fewer people are going to get their petitions in or pull the trigger and decide to run. Second, Referred Law 19 says to people, you have to get more signatures to get on the ballot, at least if you're a party member. You make Republicans, Democrats, party members get more signatures, Fewer of them will make the ballot. You'll have fewer candidates. And thirdly, and most importantly, Referred Law 19 takes away your right, if you're a Republican or a Democrat, to sign a petition for an independent. Independents can only get signatures from other independents, and that's been proven empirically to basically bar independents from getting on the ballot. That's fewer choices, less options for us voters. And I welcome your questions about this bill.
The first question is, what specifically does SB 69 require?
That's a good question. There are 24 sections to the bill, and there are a lot of changes that I probably won't go into this evening. Some are trivial, but the big thrust are the three that I listed at the top. Let me elaborate on that independent side of things, because really, and we heard Mr. Noby talking about Amendment V and its benefits for independents. Referred Law 19 was another post-Pressler, I'll be honest, Republican attack on independents' ability to participate. Larry Pressler only got 17% of the vote, but it doesn't take much to scare Republicans, apparently. So, the independents, here's what 69 does. It says to independents, we won't make you collect as many signatures. It actually cuts the number of signatures that independents have to collect by, I'm going to roughly say about 60%. Though like Mr. Hildebrand, I don't want to do math in public. But in return, it takes away 80% plus of the voters that independents can actually talk to. Right now, if I were an independent running for office, and if you were a room full of possible signers, I could just walk around and say, are you a registered voter? Want to sign? Awesome. And maybe you will or won't, but I can try everybody. An independent, and in this room, by the state stats, 80% of you are probably voters. Probably more since you're here at this forum, but 80% of any given group in South Dakota will be voters who can sign an independent petition. Under Referred Law 19, the independent is required to ask, well, are you an independent? They've got to snoop into your party registration, and that cuts down the number of people an independent candidate can solicit to 12% of the room. So you go from 4 out of 5 people in the room to maybe 1 out of 8. That makes it hard to get on the ballot if you're an independent.
Thank you. A question related to part of the answer you're giving. Do Democrats or Republicans petitions signed only by registered voters of their party?
Right now, Republicans can only get signatures from Republicans, and Democrats can only get signatures from Democrats. And that's the nature of the party system. When you're part of a party, and you have the advantage of a party organization, well, Democrats and organization is an oxymoron, but we've got some of it. When you're part of a party, you have lots of advantages. You've got a primary system. You've got party leaders who will organize for you. When you're an independent, that means you're on your own. That's the meaning of the word. You're out there on the street doing your own thing. You don't have an organization. To say that independents need to be treated like a party, and that's one thesis I've heard Republicans offer on this bill, is really absurd. The whole idea of being an independent is we're not a party. We're not a member of either party, and we're here to appeal to all voters for our nomination. That's the nature of being an independent. So to put independents and party members with all their advantages on the same level in this case is really logically and practically absurd. Party members have all sorts of advantages for getting signatures, doing all that day-to-day organizing, not to mention then their network of donors and all that to help themselves get through an election. To say to independents, well, you too only get to talk to independents, assumes that there's an organization and a unity of independence and a mission of independence that there's not. And frankly, it goes the other way too. Republicans, Democrats, if you're unhappy with who your party has nominated or their failure to nominate someone, right now, Republicans, Democrats, others, you have the right to nominate an independent. Why take that right away?
Thank you. Another question, why can't the state office give the benefit of the doubt to the Postal Service and let us continue to have the deadline be a postmark?
That's another good question. Another thing that Referred Law 19 does really gets into the election nerdiness of how we do our petitions. Right now, you have to submit your nominating petition, if you're a party member, by the last Tuesday in March. It has to be in the secretary's hands, or you have to put it in the mail and get it stamped registered mail. Not certified, but registered mail by the deadline. And then, if that petition trickles in a few days later, the secretary gets it. As long as it's got that postmark in its registered mail, the secretary accepts your petition. Senate Bill 69 takes that away. Referred Law 19, excuse me. Referred Law 19 takes that away. It says the petition must be in the secretary's hands right away. The justification, well, if there were a proponent here, if they had the guts to do so, they could tell you, well, it's so the secretary knows the day of exactly how many candidates there are. It's not really that big of a deal, folks. There were 6 candidates who sent their petitions by mail this year and got on the ballot because we give them that grace period. Plus, consider, the vast majority of South Dakotans live 3 hours away from the state capital, 3 hours away from where they have to submit those petitions. If it's the last day and something comes up, your kid is sick from school or the candidate gets called into work or there's a blizzard, that can happen in March, why should we punish that candidate? We let that, they've done their work, they've gotten the petitions, they've gotten their notary stamp, they put it in the mail, registered mail. Why not let that happen? Why put people who live further away from Pierre at a disadvantage compared to maybe people who are closer by?
Thank you. The next question. The deadline was moved to early March to allow time to challenge petitions as there is a fixed date for printing ballots. How do you propose giving adequate time for challenges?
A little story, a very little story. I've only got 90 seconds. Senate Bill 69, what it was originally called, Referred Law 19, is kind of my fault. Back in 2014, I submitted a challenge to a nominating petition, Annette Bosworth Senate petition. Between the time of the submission of that petition and the time the secretary had to certify the ballot and put it out there was about 3 weeks. That's not a lot of time to do a challenge. That was the Secretary of State's and the Board of Elections' original intent. Then the legislature got a hold of this bill and just tore it all apart and did all these other terrible things. I understand the rationale of moving that deadline earlier to maybe allow challenges to happen. But I think there are better ways to do it that don't disenfranchise people and leave us with fewer choices on the ballot. One of the easiest things we could do is, instead of making candidates submit earlier, instead of making candidates pull the trigger and decide before the legislature even lets out, I mean, a lot of people don't decide by March 1st. They need to see what happens at the legislature before they decide, yes, I need to run, I need to fix what's going on in Pierre. Instead of moving this deadline so absurdly early and extending the campaign season, how about just have our primary later? Let candidates submit their petitions by June 1st, have the primary in the summer like lots of other states do, no problem, and then boom, primary happens during the summer, good weather for campaigning, the general election is decided in August, maybe even Labor Day, and then you've got 2 solid months of general election campaigning. I think people would love a shorter campaign season much more than having to sign petitions at the Christmas party.
Thank you. And we're going to go to closing statements on Referred Law 19. And before you do offer your closing statement, I want to remind folks that you can submit questions here in the room through cards. And if you're watching at this time, you can call in questions by dialing 367-7900, and you can email siouxfallslwb@gmail.com. Our next 3 topics are going to be Referred Law 20, Constitutional Amendment S, and Initiated Measure 22. So if you have questions out there, you can get those to us in the room. But with that, let's hear a closing statement regarding Referred Law 19.
1 minute, right, Steph?
1 minute.
1 minute. Referred law is bad democracy. It's a power play by established legislators and parties who want to keep their hold on power and largely keep independents out. Secondly, keep challengers out. Thirdly, keep you from having as many choices as possible on your ballot. I know I've said a lot of bad things about Republicans. You can tell I'm kind of suspicious of those guys. But this is bigger than that. This is about democracy, small d democracy. This is about giving as many people as possible a chance to participate in the process. It's hard enough to run for office. I'm doing it right now. I speak from experience. It's hard enough to get people to run for office. South Dakota doesn't need to make that harder for people. We don't want to build barriers to participating in the process. We don't want to reduce our choices. We want to invite people to participate in the process. Referred Law 19 is a big barrier that says, don't participate, don't run, we're going to make elections longer, we're going to make campaigns longer, we're going to make it harder to get petitions signed, we don't want you to participate. Don't stand for that. Keep your choices, keep your options, protect democracy, protect your rights. Vote no on Referred Law 19.
All right, thank you, and I'd like the audience to thank Mr. Heidelberger for giving us a question on this one. And with that,
Y'all come back now. Here.
What kind of morons run this outfit?